Okay. Hello, everyone. Welcome to today's Sanderson Firm webinar. It is 1:30 p.m. Eastern Standard Time, so we're going to go ahead and get started. Thank you all for joining today's webinar. I have kind of come on this webinar impromptu, decided to jump on this morning. I just want to see the webinar myself, say hello to all of you, and we have a little surprise at the end of the webinar that I want to share with all of you. So make sure you stay tuned to the end. But today's webinar is called Cause and Effect, How Section 111 Reporting Can Make or Break Your Conditional Payment Workflows. My name is Heather Sanderson. For those that don't know me, I started Sanderson Firm in 2021. I've been doing Medicare secondary payer pretty much my entire legal career, close to 20 years now. I'm proud to have a phenomenal team here at Sanderson Firm. Two great attorneys here on the webinar today to talk to you about the intersection of Section 111 and conditional payments, which is very much intersected, right? It's a lot to understand and take in, and they're going to do a great job of breaking that down for you. So I'm going to kick it over to Annie Davidson to introduce herself, and then to Kayla, and then we'll get started.
Hi, everyone. Welcome to another wonderful Sanderson Firm webinar series. My name is Annie Davidson. I'm one of the attorneys here, and I've been here since January, but like Heather, I've been in the field for quite a long time. I actually cut my teeth on conditional payments when I was in private practice. So I used to handle work comp, liability, and insurance defense claims when I was in private practice before I caught the Medicare bug around, 2013. So happy to be with you all.
Hi, everyone. My name is Kayla Pigeon, another attorney here at Sanderson Firm. I've been in the MSP space about 9 years now, which seems wild to think about. Medicare, as Annie says, bites you, and then it's all you do for the rest of your career. We love it. Yeah, and I started at a large carrier before coming to Sanderson Firm, coming up on close to 3 years now.
Great. Just a few housekeeping items. Those of you that might have questions, feel free to populate those in the chat box here in the Zoom. We'll be happy to get to those at the end of the presentation. Also, there'll be a survey following the webinar. We really appreciate your feedback on today's webinar and also future topics that you might like to hear from us. So with that, let's go ahead and get started. Just a little bit about Sanderson Firm. We pride ourselves on having unmatched, innovative Medicare secondary payer expertise. Medicare secondary payer services is all that we do. We are proud to be a woman-owned business. So we are woman-owned, and we have a lot of females that work here. And that's not for one reason or another, just come across some great talent that just happen to be female, but we are proud to be woman-owned. We have a national footprint across the country of clients, also employees as well. Our clients are comprised of third-party administrators, insurance carriers, self-insured entities, governmental entities, and we've done work across the country because Medicare secondary payer is a federal matter. We are able to assist clients in all states across the country. Our team of 60 some employees is comprised of legal, clinical, and claims professionals. So we have varied expertise. We're proud of our combined and clinical and legal approach to every claim and our consultative approach in helping our clients achieve Medicare secondary payer compliance settlements. Across the 60 some employees, we have more than 500 years of combined experience. So while Sanderson Firm is only about 5 years old, we've been very grateful and fortunate to hire some great talent that has spent a lot of time in Medicare secondary payer before coming over to Sanderson Firm. And we are really appreciative of your time here today. Let's go ahead and get started. And I'm going to kick that over to, I believe it's Annie, to start with the agenda.
Perfect. Well, we will level set here with the agenda. We will start out with just a little CMP reminder from Kayla, and then we'll set the stage with a couple of the things we'll be talking about, right? Just a level set on conditional payments and Section 111 and how they intersect. Then we'll dive right into the recovery contractors, recovery models for traditional Medicare. This webinar will focus really heavily on interacting with traditional Medicare. While you do interact with Medicare Advantage plans and Part D plans when you're dealing with recovery issues, particularly with Section 111 issues, you're really set in the traditional Medicare world with their very rote process So that's what we'll be covering today. If you have questions about those other things, you can certainly call us, email us, text us offline, and Kayla and Heather and I will be happy to answer any of your questions. We will then dive into our cause and effect examples. If you've seen Kayla and I present together before, this kind of tends to be one of our things. We like to have a theme, and then we like to kind of just riff on that as we go. So you'll see there we've got some of the examples that we'll be going through, and then we'll leave you with some takeaways, and then we'll kick it over to Heather for that wrap up and that little surprise. So that's our agenda. We can move to the next slide. And Kayla, on to you.
All right. Thank you, Annie. So as Annie said, we just wanted to give a brief reminder here that civil money penalties are almost upon us, right? So that final rule regarding civil money penalties was originally published on October 11th of 2023. It became applicable, meaning claims started being potentially eligible for being reviewed for CMPs on October 11th of 2024. And now we're moving to that potential enforcement of those CMPs on October 11th of 2025. As far as information we know about, as far as how Medicare is going to start sending these, we know that while enforcement technically begins October 11th of 2025, we likely aren't going to see any mailed correspondence happening until the first quarter of next year, so Q1 of 2026. When we start receiving those notices, they'll start with informal notices of potential CMPs. RREs will at that point have about 30 days to review for mitigating evidence, submit that over. In the event that Medicare determines there's still a potential CMP here, they'll move to a more formal response, at which point you'll start moving into the formal appeals process, whether that's with the administrative law judge or moving up the appeals. So like I said, CMPs are beginning less than 2 weeks away. We hit that enforcement date. And lastly, as a reminder, generally they have now moved to a tiered approach with those CMPs. So it'll depend on how long that claim is out of compliance. All the amounts are adjusted per inflation, but up to $1,000 per day per claim.
Awesome. Thanks, Kayla. So I'll do a quick level set on Section 111 reporting, and I'll turn it back over to Kayla then to do the level set on conditional payments. So for those of you who might be a little bit new to this or just want the refresher, what is Section 111 reporting? Well, there was an act, the MMSEA Act was passed in 2007, and the requirements went live in 2010. What Section 111 really stands for is the fact that responsible reporting entities or primary payers or applicable plans, you name it, there's different ways of referring to these folks. So these are liability carriers, including self-insureds, no-fault carriers, work comp. All of them have to, also called non-group health plans, all of them have to make sure that when they settle with a claimant who happens to be on Medicare, that they report that information to Medicare, and if they pick up a claim, right, you admit a claim with a beneficiary or that person becomes a beneficiary during the pendency of the claim, Medicare wants to know about it. That's ongoing responsibility for medicals. You're assuming responsibility for medical payments. So if you hear us refer to ORM, which we will, that's what we're talking about. Ongoing responsibility for medicals says these non-group health plans have to tell Medicare when they have a claim involving a beneficiary. You have 1 year to do that from the date of the claim if they're already on Medicare, or from the date they become eligible for Medicare. You got to let Medicare know. And then the payment of a settlement, that's referred to as a TPOC, or a total payment obligation to the claimant. That's usually a settlement, judgment, award, or other payment, closing out future medical benefits for that Medicare beneficiary. So again, we'll be using some jargon here, ORM and TPOC. This really helps Medicare coordinate benefits. That was always their plan. If you've been doing this a while, like we have, you remember prior to 2015, and the Section 111 world and the conditional payment world really didn't interact. When I would go out and train, and I'm sure this was the same for you both, you would train and we would talk about conditional payments, we'd talk about Medicare set-asides, and we'd say your technology team, your vendor, like somebody else is doing Section 111, don't even worry about it, right? It's happening. Now it's something that's very important to make sure claims handlers understand at the desk level where that interaction and interplay is. So that's where we come in with this webinar today. But at the end of the day, this helps protect the Medicare trust funds in Medicare's eyes. So that's really what it is. They want to coordinate benefits using Section 111 data, and then to the extent that they find conditional payments, they want to get that money back. So I'll turn it over to Kayla to explain that level set.
All right. So Annie touched on, what is Section 11 reporting, and now we're just going to talk about what is conditional payment. What is a conditional payment, right? So at its heart, really, the definition of a conditional payment is a payment that Medicare has made for Medicare covered services where there is another primary payer. So if, for example, someone is in an automobile accident and they're on Medicare, they go to the emergency room. There may be another coverage, another primary payer that's really responsible for payments for the injuries suffered in that automobile accident, but Medicare will make those initial payments on the condition that they can recover from that primary payer if they determine that there is a primary payer. Part of this helps to not hold up treatment at the time of emergencies. But just as a general matter, it's, Medicare makes these conditional payments and they have the ability to recover if they determine that there's a primary payer. How do they know there's a primary payer? They're only going to know if there's a primary payer through that Section 111 reporting. So this is where we start to see the interplay. Conditional payments are not going to happen. Medicare is not going to realize they exist without understanding that there's another primary payer through the Section 11 reporting. Conditional payments are made not only by traditional Medicare, but by the Medicare Advantage plans as well. So those are going to be your Part C and Part D plans. Quick reminders here, just why do we care about conditional payments? They can be very time sensitive, right? So conditional payments can have tight deadlines. We want to make sure we're meeting deadlines. We don't want to lose appeal rights. Interest can accrue. Things can be sent to the Department of Treasury. That's specific to traditional Medicare. Medicare Advantage plans cannot send conditional payment debts to the Department of Treasury. And then most importantly, conditional payments, if they go unresolved and there's a need to pursue litigation for Medicare to recover those conditional payments, then they can be entitled to double damages. And not only do they have this double damage ability, but also this priority right of recovery, which means that Medicare can actually recover from any party to the settlement. This applies to both Medicare and Medicare Advantage plans. So despite any language you may have in your settlement, conditional payments can be recovered from the carrier, they can be recovered from plaintiff attorney, they can be recovered from beneficiary. Medicare can and will recover its conditional payments, and they can do that against any party to the settlement. So now that we've kind of touched on what is Section 11, what is a conditional payment, we're going to start talking about how those different Section 111 reports prompt conditional payments and how that interplays with Medicare's two recovery contractors. So the first recovery contractor that we're going to talk about is the Commercial Repayment Center, sometimes referred to as the CRC. When we talk about the Commercial Repayment Center, their recovery, their contract that they have for recovery with Medicare and the scope of recovery that they are engaging in is entirely based on ongoing responsibility for medical, that ORM, being reported as yes. So if we have accepted workers' compensation claims, accepted no-fault claims, either for PIP or MedPay, where we have that ORM yes, these are the claims that the Commercial Repayment Center is going to be reviewing and determining if there are conditional payments associated with them to send those conditional payment letters and liens. When we talk about who they recover against, because ORM is yes, we have that ongoing responsibility for medical, meaning that the RRE, the responsible reporting entity, is the one who is responsible for making these payments. So they're going to be recovering against an insurance carrier, a self-insured party, not the beneficiary, for example. And when we talk about the Commercial Repayment Center and this ORM recovery, some people refer to this as the continuous recovery model. So what that means is that as long as that ORM is reported as yes, CRC can continue to recover against that claim. So not just one recovery action could happen, multiple recovery actions could happen as long as that ORM remains yes. So you could resolve a conditional payment, a demand could issue, you could pay, you could dispute, however that happens, that case could close. But again, as long as that ORM remains open, the CRC is going to continue to potentially recover against that claim. So that's the CRC, the ORM recovery, the continuous recovery model. I'm going to kick it over to Annie to talk about our other recovery contractor.
Thanks, Kayla. Yeah, so when you heard me say earlier, those of you who are doing this prior to 2015, that was what I was referring to. The Commercial Repayment Center entered the space in October of 2015, and it shifted everything that we were doing. It was a little bit of the Wild West if you were doing this prior to that. Medicare had started to routinize the process, If you go even further back, and you've been doing this a long time, you might remember when there were regional areas like Meridian out here in the Midwest where I'm located. Depending on where you were in the country, there were different contractors that were working for the federal government to get the money back. What they were doing is basically what now is covered by the Benefits Coordination and Recovery Center. They were kind of doing all of that work prior to 2015 when it had become routinized. We call them the BCRC as well. Recovery here is going to be based on the report of a TPOC, a total payment obligation to the claimant. That's your settlement, judgment, award, or some other payment, closing out those future medical benefits on the claim. In this case, you're primarily looking at denied workers' compensation claims and liability claims where ORM equals no. So CRC jumps in when ORM is yes. It's very rare to see that in a liability claim, but ORM no, your liability claims and all your denied work comp claims hang out here. At this point in time, what Medicare is looking to do is they're looking to recover post-settlement. They may send out some letters and notices ahead of time. Particularly, you'll get notices and demands if you settle the claim and you didn't check with them beforehand. These folks have no idea your claim is out there. So with the CRC, it's an admitted claim. Medicare knows you're out there. Here, somebody has to contact them ahead of time. That's a huge part of so Kayla, she's very, modest. She oversees all of our conditional payment work here and our Section 111 work. She oversees both teams. And we have folks every day that are just doing this, that are putting Medicare on notice saying, hey, look, there's this denied claim out there, or there's this liability claim out there. They're getting ready to settle. Can you send us a conditional payment letter? And we can start to investigate whether those payments are related or not. Again, if you do nothing and you just let the TPOC slide through, what will happen is they'll kick out a notice, and then about 30 days after that, you'll get a demand, and Medicare will want to get repaid. Who are they asking to get repaid from? They're actually seeking the beneficiary or the beneficiary's estate if that person is deceased. So a proof of representation letter is what's required in these instances for third parties to conduct the conditional payment work on behalf of that beneficiary. Again, a large part of the work that we do here. If you are handling these types of claims in-house and you have somebody who's pro se or pro per, these are things that you want to farm out. You are directly adverse to this person, and having them sign a beneficiary proof of representation form means that you're representing them in their interest. So you can see how quickly a conflict could arise. So it's really important that this work get done, and just know the debtor is the beneficiary. Even if you're the carrier and you're going to clean it up and pay it, that's fine, but the beneficiary or beneficiary's estate has to be involved in order to get this done. And then Medicare's only looking to recover once here. So this is not that rolling recovery or continuous recovery that Kayla talked about. This is a one and done. So the claim has to have been settled. You have to have a signed executed release that's been approved in that jurisdiction if it's comp, or if you're in a liability claim, just make sure that that is fully executed. Then we can provide that to Medicare, or someone can provide that to Medicare to get them to issue a final demand, but the case does have to be settled. At that point in time, they do a final sweep. They check to make sure if there's any conditional payments out there that they get repaid. And then just in both cases with conditional payments, there's 3 years from the date of that settlement to pursue that final demand. There's a 3-year statute of limitations. If they don't get their money, they will send it to the Department of Treasury. They don't usually sue for double damages, although they can. They haven't done that since about 08, 09. they're really sending stuff to Treasury at this point. And because the debtor is the beneficiary, they will look to garnish any federal benefits that person has. They'll recapture that person's, tax refund. They will try to get their money any which way they can. But all parties need to make sure that you're, taking care of conditional payments, even if it's a denied claim and you didn't pay anything. The carrier or your self-insured, you're still in the mix as one of the parties that Medicare could target within those 3 years. So it's very important to make sure these are researched and repaid. So that's what I've got on the TPOC part of things. Back to you, Kayla.
All right. So I talked a little bit about the CRC and ORM. Annie talked about the BCRC and TPOC. What we're moving into here is what we tried to do for you all is put together a flow, right? How we sort of move through the determinations on the claim and the Section 11 reporting that happens and how that interacts with conditional payments, right? So again, when we first get notice of a claim, we're going to be determining if it's accepted or denied. When we're determining if it's accepted and denied, we're also going to be reviewing for, do we have ongoing responsibility for medical? If it's an accepted claim, it's breached the reporting thresholds, then we're going to be reporting ORM as yes. As part of that reporting of ORM, we're going to be populating all of the information needed to file that ORM as yes. That includes what the injuries are, right? So we have to tell Medicare when an injury occurred, what the date of injury was, what the injuries were, as well as any other information. And that can vary based on line of business. So for example, if we're talking no fault, we might need to also include things like policy limits when we're reporting the realm of our ongoing responsibility for medical. So all of that information is going to get sent through our Section 11 reporting so that Medicare can appropriately determine that there's this other primary payer. Then once all of that information has been reported through Section 111, that's where we start seeing that CRC recovery, right? That commercial repayment center recovery that's happening on that continuous model. All of that information that we've reported in our Section 11 reporting gets populated in what Medicare and the contractors refer to as the common working file. And they use that information in the common working file to develop their leads, right? So that's what the injuries are, the date of injury, again, those policy limits. And that's what the recovery contractors, the CRC in this example, is going to use to review and search their Medicare payments and see if there's potential conditional payment liens. And again, that recovery is going to happen continuously until potentially we hit our third section in this workflow, which is ongoing responsibility for medical termination, so ORM termination. A little later in the presentation, Annie will dive a little deeper in when and how we can terminate ORM, but it's important to know that ORM termination is one of those things that can cease recovery with the Commercial Repayment Center. The other piece of this, so ORM termination can happen on its own, but it can also happen in conjunction with a settlement. So when that settlement's happening, we might also be reporting a TPOC, that total payment obligation to claim it. Again, that TPOC can happen both with claims that had that accepted ORM or claims that were denied and now we're just issuing that settlement payment. But either way, if we are reporting an ORM termination and a TPOC, that's going to cease any of the recovery that was happening with the CRC, but it's also going to now prompt recovery with the Benefits Coordination Recovery Center. So you see as we're moving through this, the different Section 11 reports are starting and stopping things within the process of conditional payments. And this final aspect of the TPOC, the total payment obligation to claimant, is reporting our final settlement, prompting the BCRC to do its own search. So they're going to do that one-stop shop sweep that Annie was talking about, that final demand process. But they're actually utilizing that same common working file that the Commercial Repayment Center did in order to identify conditional payments and issue their conditional payment liens as well. So now that we've kind of walked you through the process, we're going to start to actually go through some of these examples of effects that we see on our conditional payments, what the Section 111 cause might have been, and then also the potential resolutions in those scenarios.
Just going to jump in.
Oh,
I'm
yeah.
just thinking about here. Just want to make sure everyone is clear, and I don't want to divert too much. But when we're talking about BCRC and CRC and this information flow that Kayla's been talking about, we want to make clear that this is for traditional Medicare conditional payments, right? So today we're not talking about Medicare Advantage plan conditional payments, those private Medicare liens. You're only going to receive traditional Medicare Part A and B conditional payment correspondence from the BCRC and the CRC. And so I just want to make everyone aware that Medicare Advantage plans are a concern, but those conditional payment liens don't go through these contractors. And I don't believe we're discussing Medicare Advantage plans today. But they're heavy on my mind here today because we've been seeing Medicare Advantage plans and their assignors become a lot more ambitious with their pursuit of recovery lately. I know Kayla, you've seen some letters. MSP recovery is back in the mix. And again, I don't want to digress. I know we've got a lot more to cover, but me sitting here listening to this, I just want to make sure everyone's aware. Did you want to add anything about that, or did I miss where we're covering that in the presentation?
No, I mean, we touch on items that do also affect Medicare Advantage plan recovery, but not in the sense with this workflow where it's very specifically prompting certain items. Medicare Advantage plans do get past Section 11 data and they do utilize it in their own recovery. So some of the items we talk about are important there as well.
Yeah.
But really, when we start really getting very specific about the contractors, yes, it would be specific to traditional Medicare. But we can try to pull that in some areas as well.
I think it's just the key point, Kayla, like you said,
Yeah.
the Medicare Advantage plans do get this data eventually, right? And that's how they're also driving their conditional payment processes, which are separate and outside of today's webinar. That could be another future webinar, but just want to make sure everyone is aware that this is just for traditional Medicare conditional payments. So
Yes,
thank
Section
you.
111 and Medicare Advantage plan conditional payment processes have their whole other host of issues and delays and things that we see. So certainly an additionally good topic to discuss for sure.
For sure. Thank you.
All right, so as we said, we promised we are going to give you some specific examples. And as we're going through these, just one comment I'd like to make is if we are getting any sort of conditional payment situation and we're dealing with traditional Medicare, like we said, the first question I'm always going to ask, and I'm always going to ask clients if we're looking at something where a letter's coming to us unexpectedly, we're getting responses we didn't expect, anything odd like that. The first question is always what is going on with the Section 11 reporting, because that really drives so much of how your conditional payment processes go. So you'll see that as a theme as we go through every example. This first example that we're talking about is when a conditional payment letter is issued from the Commercial Repayment Center on a denied claim. So if we have a situation where our claim is denied, we have no ongoing responsibility for medical, we shouldn't be receiving any conditional payment correspondence on that claim unless and until that claim were to settle above threshold. Um, Most likely what's happening if we're seeing this type of correspondence is incorrectly an ORM has been reported. Um, this can happen for a host of reasons. I'm sure Annie has seen many different iterations as well of this and her work with conditional payments. One of the most common, I think, that we see nowadays is certain automations in our claim systems, especially if we have things like now we have civil money penalties coming down the line, right? We want to make sure we are filing our Section 11 reporting timely, which means a lot of us have put in different automations that are triggering that ORM to be filed based on different things in the claim system, right? Unfortunately, what this does is it does sometimes cause incorrect ORM to be reported. And 9 times out of 10, I'd say if we're receiving incorrect conditional payment letters on a claim where we shouldn't have an ORM, it's because one, we've incorrectly reported something, and two, it's potentially because of some automations in the system. So if we're seeing this, a review of the file should occur in that situation. Depending on the claim facts, it might be that we're filing a delete. We could be filing an ORM termination. That's really going to be case specific. I can't tell you exactly what will have to happen in each scenario. without more detail. But then also, once we decide what that update needs to be, then a dispute or appeal needs to be filed. One other theme I want us to keep in mind as we're going, through this whole thing is in these situations, not only do we need to correct and update the Section 11 reporting, but we still need to file that dispute or appeal. Sometimes there is this misconception that just updating the Section 11 reporting or just filing the appeal is sufficient. We really need to do those two things together to ensure that, one, we're successful in our dispute or appeal, and two, we prevent the continual conditional payment issue that we are seeing in the first place. This next one, again, it's another sort of riff on this idea of us having an open ORM that's maybe not quite right and receiving a conditional payment letter. We see this, I'd say this is a really common thing that we see, where we are getting a conditional payment letter on a claim that's maybe been administratively closed for many years, and everyone is confused, not understanding why conditional payment is cropping up on something that's been closed for so long, where no payments have been made in quite a long time. 9 times out of 10, again, it's because, one, our ORM is currently still open. And that could be appropriate based on the facts of that individual claim. That could be 100% something that needs to be happening based on our reporting guidelines, based on the state statutes, etc. But it also could mean that maybe we have an opportunity to terminate that ORM. And Annie's going to talk more about why and when we get to do that. But if we are having a situation, we're getting a conditional payment letter, we don't think there should be any recovery on this claim, there is a potential that we should review for an ORM termination, because again, if we aren't doing that, that continuous recovery is going to keep occurring on that claim as long as that ORM remains open. I do have a note quickly here that this also could apply if we haven't properly terminated ORM in a situation where we haven't exhausted no fault policy. But with that, I'm going to turn it over to Annie to talk about that termination of ORM.
Perfect. Thanks, Kayla. And I know we had a question in the chat about terminating ORM based on policy exhaustion versus, the amount of time available on that policy for a claim to be filed. So hopefully this slide will help clear some of that up, and we'll walk through it here. So in terms of terminating ongoing responsibility for medicals, if we link back to what Kayla said at the outset about civil money penalties, this is not a basis for CMP, right? It's timely report of ORM, timely report of TPOC. If you are untimely in reporting ORM termination, you're basically just hurting yourself, because Medicare thinks the claim is still open. They will continue to send correspondence, and they'll continue to ask to get repaid because they think you're still responsible. So it's important to populate this information. It's also a good heads up that most claim systems should be able to handle a date in the future, but certainly Medicare's system can. So if you are handling your Section 111 reporting internally, you can house dates into the future, because Medicare will accept those. If you report through us, you're probably already aware of that, but want to make that point, because you can set these in the future. So what are the reasons to terminate ORM? The date of policy exhaustion, if applicable. And the question of the chat in the chat was, hey, is it, which one do you go with, policy exhaustion or kind of the term that's available on, let's say, that no fault policy? You're going to go with whichever one comes first, essentially. So if the policy exhausts before that is typically 1 year, you will report your ORM termination date as of the date of the policy exhaustion. If the policy has not been exhausted and you hit that 1 year term, then you would go ahead and enter that 1 year term, and you do not have to do anything further with that policy exhaustion, right? Those funds aren't available. Now, if for some reason you went ahead and paid that later, let's maybe talk about that offline. I'd like to know what's happening and why you sort of went past that. But those are reasons to terminate ORM. The policy is exhausted, or they didn't submit a claim within that time period, right? So that's also a statute of limitations argument. In some jurisdictions, there's a statute of limitations that's applicable. If that runs, you go ahead and enter that as your ORM termination date. If the claimant dies, their date of death is the ORM termination date. If the injury resolves without the need for future care and they have a statement from the treating physician, you can go ahead and enter that date that the doctor says in the letter. If it's not the date of the letter, otherwise you'd use the date that the date of the letter that's provided by the doctor or where it is in the treatment records. It's the date of your settlement, judgment, award, or other payment, so it's the date of your TPOC. If nothing else, you can terminate ORM on the date of your TPOC. You do need to still enter an ORM termination date. To some of Kayla's other points, like in terms of filing these disputes and appeals, you got to run both tracks. You got to run both tracks here too. You got to report your TPOC and then also terminate ORM. And then if there's a denial of benefits following an investigation period at the outset, you would accept ORM for that period that you're investigating. And then if you decide to deny the claim based on your investigation, you would enter an ORM termination date. ORM is not an on-off switch. It's not yes, no, you don't change it. Once it's yes, it's typically always yes, unless it was a mistake. And then you're likely sending a delete record, like Kayla indicated. When you're self-insured, this all works the same. This applies to carriers, self-insured. You have to make sure that you're entering this information. If you have a third-party administrator that you're working with, they're probably taking care of this for you. If you don't, certainly get in touch with us. We can help you. If this is causing you some agita or something, we know we're on the precipice of civil money penalties. So just get in touch with us. But then there's also in states like mine, so I practice in Minnesota, there's no statute of limitations in work comp. So administratively open files are just there and you administratively close them. And when that person gets on Medicare, then all of a sudden something can pop back up. So in jurisdictions where you don't have a statute of limitations, Medicare has allowed us to use this 5-year, $25,000 rule. So if there's no statute of limitations, the carrier or self-insured can use this 5-year, $25,000 rule to terminate ORM where they otherwise wouldn't be able to. So it has to be all of these items met, then you can go ahead and enter your ORM termination. So there's no practical likelihood of associated future medical when you meet all this criteria. No claims were paid with any diagnosis codes related to alleged ingestion, implantation, or exposure. So these aren't going to work for your exposure claims. If there's been ingestion or implantation, you can't use this. No claims were paid for any medical item or service related to the claim within 5 years of the date of that service of any such claim. Like 5 years from the last date you paid for a service is when you would go ahead and enter the termination date. But then you also have to make sure the treatment itself didn't include payment for implantation of some sort of medical device or a prosthetic device. Those would be ineligible then. And then the total amount you've paid up to that point for medical on the claim cannot exceed $25,000. When all of this criteria is met, you can go ahead and terminate ORM. If and when one of these items is no longer met, you have to go in and remove that ORM termination date. So that's what we're talking about with the 5-year, $25,000 rule. Kayla, I know you've been answering some questions in the chat. Do you want to jump in here and clarify anything before we move on to some more cause and effect examples?
Yeah, I think I've covered a lot of the things in the chat. One thing that was asked about was how this works if you're a self-insured, and the answer for that sort of depends on if you are directly handling your own Section 11 reporting or if you're utilizing something like a third-party administrator. So if you're utilizing a third-party administrator, it may be worth having conversations of if they're proactively looking for things like ORM terminations and ensuring claims are being updated. If you are actively handling your own claims, then it's just nothing changes as far as the criteria. It's just implementing them within your own claim processes.
Awesome. And I'm seeing some of the questions come up in the chat too in terms of like around assuming ongoing responsibility for medicals. We're not going to really focus on that today, but we can answer that offline. Medicare did clarify when you should grab ORM and report it. It's particularly helpful with no-fault claims. And for those of you in no-fault jurisdictions where there's no time limit, we can answer that offline about what to do in those specific scenarios. Because it doesn't require going above and beyond. It's sort of normal routine investigation of your claim. All right, so I'm going to keep chugging along here. So policy exhaust dispute with section 111. The CRC is not agreeing with your dispute based on an exhausted policy. So your funds are gone. You've written to Medicaid, right? They sent you something. They say, hey, we need money. And you're like, look, I don't have any more money. We've already paid it out. We reimbursed this person for all of their out-of-pocket expenses. And it ate up our $1,000 or $5,000 deductible, or excuse me, the limit. So in these cases, there's usually a couple of section 111 items that can contribute to this. One is that lack of populated ORM term. You terminated ORM, your policy exhausted, and it just didn't get populated. Or you have an incorrect or absent policy limit, so Medicare doesn't know that you've hit that. The other thing to think about with your no-fault MedPay PIP claims, a lot of times when that policy limit is low, when it's 1,000, 5,000, even 10, it can go fast, right? So by the time you do your first Section 111 report, and I guess we should have covered this sooner, you're reporting Section 111 data quarterly. So Medicare is always behind, right? In the MedPay PIP world, you're going pretty fast. You're paying out for that treatment as you should, and you might exhaust it very quickly. If you kind of do all of that in the span of like a week or something, great. Your ORM report, when you go to report ORM, you're also reporting your exhaustion at the same time. It's all going over, and there should be no recovery contractor involved. But if you reported last quarter, and then your exhaustion happens right after you reported, your exhaustion isn't going to go until the next quarter. Number one, you might want to think of a best practice of calling that in to the BCRC. They hold two contracts, one for recovery and one for Section 111 reporting. You can get that ORM termination reported more quickly via the phone. You still have to do it via Section 111 reporting. It does not obviate that. But you can tell them sooner so that they can go ahead and do their final check, and close out their case, et cetera, et cetera. But really, you want to make sure to double check your Section 111 data here. If the CRC won't accept your dispute, you've said, I don't have any more money. A lot of times, if it's one of these two things happening, sometimes they can be pretty persnickety, and they'll want to see, and it's different in the no-fault world than in the comp world. They'll want to see your ledger of how that money was exhausted. They can get very persnickety. It's very annoying, but it is something that you have to do, unfortunately, is show them, how the funds were exhausted. But yeah, so this is something that happens with policy exhaust. You can certainly dispute and push this through and clarify these items if you have to. Kayla, anything to add on this one?
Not specifically. We have a few questions in the chat if it's an okay time to address a couple of these. A couple things just to clarify is ORM, if we had ORM yes, and then we're later determining that it's now a denied claim, that's different than if we're it's going to be really dependent on the claim scenario if we're filing what we call a delete or we're filing the ORM termination. So it's going to be a case-by-case basis. A lot of times, if it's a situation, or pretty much any time, if we originally accept the claim and we're later denying, most scenarios it's going to be an ORM termination and not a delete. As far as situations where the claim does not qualify for those 5-year for the 5-year ORM termination because it's over 25,000, for example, it could be that we don't have the ability to terminate ORM in that scenario. It may be that we need to pursue things like a physician statement, et cetera, to try to pursue that ORM termination.
Okay, we can move to the next slide then. So ICD-9 overbroad codes within Section 111 reporting. So you filed a dispute or an appeal, and the issue is, there was, let's say, a hand injury, and it was the right hand, but all of the codes you're getting show for, and let's say that was 10 years ago, and you're getting all of these codes for a left hand injury that happened last year. So there are two Section 111 issues that could contribute to this: vague or overbroad ICD codes that are being reported, and then ICD-9 versus 10. So ICD-9 didn't allow you to choose right or left. ICD-10 do. So that's a huge issue, right? Is they just don't know what hand it was. So you are going to have to explain to them. You can't mix ICD-9 and 10 codes together. You can certainly update them over time. So if you're, in this case, to resolve it, you're going to review the ICD-10 codes, or ICD codes, excuse me, that were reported. If they're incorrect or overbroad, you're going to pick a better code, get that reported, and then also let the CRC know that you filed a, an update to the reporting data and keep fighting that fight. So again, you're running both tracks. So you can file that next level of dispute or appeal after that appropriate update. And then you can update your ICD-9 codes to 10 codes. You can absolutely do that, and that will, help clarify in the future. So again, overly broad reporting. So now your conditional payment letter has completely unrelated charges, and your disputes are unsuccessful. You're kicking and screaming. They've got treatment for diabetes and high blood pressure, things like that, hypertension, and your claim is a right knee claim, right? What's going on? Oftentimes the CP liens will have charges unrelated to them. Part of that is due to a grouper technology that is used by Medicare. It's an algorithm that they're using, and it's been bad for a long time. They claim to update it from time to time and, claim that it's going to catch these things that are riding along inappropriately. Yeah, it's not perfect. It's nowhere near perfect, and that's part of one of the causes. So that's something you want to, again, always keep an eye out on what ICD codes you're using. I think we have some clients along the way that will not use pain codes at all. They view that as a symptom, right? Not as the actual injury itself. That really helps if you can avoid some of those pain codes, because those end up being overly broad, right? It's actually arguably somewhat related, maybe, but it's a pain complaint. And so it might be related to something else. So just, make sure that those codes are pretty tight and dead on, especially if the person has an underlying condition. Let's say they have arthritis in their shoulder. You do not want to just report right shoulder pain. You want to report what happened, a sprain of the right shoulder. You're going to pick that ICD-10 code. You want to be that specific because you're not buying the underlying arthritis, right? So review that and make sure that it's accurate coding, it's succinct coding, and then also push back on Medicare for their bad algorithm. Sometimes 90% or more of what they send out is unrelated due to their grouper. So it has absolutely nothing to do with your program, or maybe you have a TPA doing it. It doesn't mean your TPA is doing a bad job, or your vendor's doing a bad job, or your adjusters are doing a bad job. Medicare just has a really bad algorithm. All right, if you want to dispute a charge that has incorrect codes along with correct codes, that is really tricky. We pay attention to kind of what the lead main code is, and you're parsing some of that, but Medicare's system isn't great about separating unrelated and related. You have much better chance of doing that with Medicare Advantage plans and kind of splitting the baby. With Medicare, traditional Medicare, if the primary reason that person's treated is the lead code that's associated to your claim, unfortunately, you're responsible for that. Kayla, do you want to talk about some of these best practices for selecting ICD-10 codes as we kind of head into our last 10 minutes here?
Yeah, certainly. So, generally, when we're talking about best practices for ICD codes, Medicare in their grouper algorithm Annie was talking about, they're already casting a very wide net. They want to make sure they're identifying all of the potential conditional payments that are related to the claim. So we don't want to make it harder on ourselves by picking too many ICD codes, non-specific ICD codes, when we are reporting through our Section 111. So one of the things we can do to help that is not report, they allow you to report up to 19 ICD codes. I would say you pretty much should never be hitting that maximum. We should really trying to stick to one ICD code per accepted body part, and that would be sufficient. We also want to use those ICD-10 codes whenever possible, because if our injury is for the left hip, we don't want to report an ICD-9 code that just says hip, because Medicare is going to try to recover now if there are any other potential payments that they've made for the other hip. And now it becomes a lot harder to have that conversation with them. Instead of just saying, look, we reported left hip, you're trying to recover for right hip. Now we have to provide more evidence, perhaps get medical records. Our arguments just become harder to make. Again, non-specific codes. Annie mentioned pain codes. Reporting chronic pain is probably one of my biggest pet peeves when when I'm looking at Section 11 reporting. Um, just because, again, when we're talking about people with injuries, maybe we're talking about Medicare aged individuals, the odds that they're going to have other conditions where you could relate chronic pain to is really high. So you're really casting this really broad net of everything that could possibly be in that conditional payment lien. Um, and then you touched on, Annie, and I think it was a question in the chat as far as how do we dispute when there are some related codes and um, some related codes further down in the lien, and but the main charge is unrelated, right? For the same reason that we shouldn't be reporting everything in the medical bills, you can kind of make that argument, right? So um, if someone is going to a hospital, if they're going to a doctor, oftentimes those medical bills are going to include all of those underlying conditions. So um, that's something you just kind of have to point out to Medicare. But it's also a reason we shouldn't be utilizing medical bills from emergency room visits to pick all of our ICD codes, because we're going to start casting again that really broad net. Um, there's some other couple of tidbits in here that aren't as effective or don't affect conditional payments as much, but are important to note about ICD codes that you're picking. The first one is we shouldn't use those external cause codes that just say this was a motor vehicle accident, this was a fall. Again, that also could be very broad as far as what the injuries were. And we should also not be using incomplete codes because those can actually be rejected by Medicare. Um, but yeah, just generally ICD codes, we want to be brief, and we want to cover everything, but in a way that is not making it harder on ourselves. So I know we're kind of running out of time, so I'll try to breeze through some of these. But one thing that people don't think about when they think about Section 11 reporting is the actual effect it has on your conditional payment mail processes. So if we're receiving things like conditional payment letters that are um, already at the Department of Treasury, and this is our first notice that there's a conditional payment in this issue, um, there might be a reason to believe that something's going on with how your responsible reporting entity profile report is being reported to Medicare. We may need to be looking at things like the mailing addresses that are on file with Medicare, whether claims are still being reported on old RREs that are no longer accurate. So really we need to make sure we're reviewing and updating profile reports along the way so we don't have old mailing addresses, old information. Medicare really doesn't make sure that you've received your mail, even if they get something telling them that it wasn't received by you. They really don't do anything to proactively look into that. It's really not until it's at the Department of Treasury that they actually go realize, okay, actually this business is now here. And then that's when you find out you have that conditional payment debt, unfortunately. If your Medicare demands, so if we have a situation where we've settled a claim and the BCRC is doing that final demand process, a lot of, or most of the time, that final demand will already be reduced based on the amount of your settlement, because Medicare cannot actually recover over your settlement amount. If there are issues or they're trying to recover for more than your settlement amount, it might be just that your total payment obligation to claim it, that TPOC, has been reported inaccurately. Now, that could either have happened in your own reports to Medicare as a carrier, the TPA, or it could be because the plaintiff attorney incorrectly reported something to Medicare. So the specifics of that TPOC, including how much the claim settled for, are going to directly affect both what's in the final demand and the amount of the final demand.
Okay, in the interest of time, Kayla, I think I'm gonna skip
Yeah.
these next couple of slides so that we can cover, oh, we have quite a bit left. So we will be,
Okay.
those of you that have asked about copies of the PowerPoint and the recording, we will be sending those out post-webinar. Give us about a week or so to finalize the recording and get the PowerPoints out. But I want to make sure you all know we have another webinar planned. It's going to be Thursday, October 23rd. It's going to be out about Medicare set-asides and how to mitigate pain points. We have Deanna Lawrence, who is our over our MSA division, as well as Tracy Pendarvis moderating that one, and that will be a very useful webinar to talk about MSAs. So I believe we'll be releasing the registration for that shortly. So be sure to join us. Just briefly, as I mentioned earlier in the presentation, we do all things MSP, all types of MSA services, conditional payment services. We also are a Section 111 reporting agent to Medicare. We also do Section 111 audits. We're seeing a high demand for our Section 111 services right now, in particular, because as we talked about, Medicare is about to start auditing entities as of 2 weeks from now. We're going to start seeing that. And so we've had a lot of requests for Section 111 audits and services. Reach out if you have any questions. Now is the time to be taking a look at that. All right, and here's our little teaser. I'm so excited to share. You all are the first to know officially. This will be announced tomorrow. We're so excited. Some of you might be aware that we have created educational programs through MSP College. We have the Medicare Secondary Payer Accreditation, which is an accreditation across Medicare Secondary Payer MSAs, conditional payments, and Section 111. We are so excited that we're bringing this live and in person for the first time this coming January 12th to 13th. It's going to be hosted in Tampa. A beautiful time of year to come to Tampa. The weather is usually quite beautiful here in Florida. We're going to be presenting all of the Medicare set aside, Section 111, and conditional payment sessions virtually. And for those of you that are interested in getting the MSPA accreditation, you'll be able to then go home and take the test online. If you have questions, we do have an email address here for that. We are limiting the amount of people that we're going to have for this first premier in-person event. So if you're really interested on attending this, please sign up right away. Like I said, we're going to be releasing an email and an announcement tomorrow, which provides for information on registration. So those of you that are attending our webinar here today would probably be interested in this because naturally you're interested in all things MSP. There will be several faculty from Sanderson Firm President, including myself, Kayla, and Annie will be there in person live in Tampa next January, and several other Sanderson Firm faculty. We've also invited faculty in from outside of Sanderson Firm, from other industry stakeholders that also have unique perspectives. So we hope you can join us, and we hope to see you in person in Tampa. And again, we also still have these programs online, the Medicare Secondary Payer Accreditation, fully online. And our other accreditation that's part of MSP College is the Medicare Set Aside Certified Planner. And that's all things related to writing and reviewing MSAs. That will not be in person. The purpose of the January in-person event is MSPA focused, all things MSP. MSACP is remaining virtual for now, but we certainly hope that you're interested in that event. We look forward to meeting many of you in person. We got a lot of questions today, Kayla and Annie. Wow, this was definitely a conversation that needed to be had. We do have about another minute or so if we maybe want to take one or two questions, but then I want to be mindful of everyone's time and let everyone go.
Well, Heather, we're actually getting some questions about the MSPA certification, so I'll answer those and then we can let everyone go. And folks who don't have an MSPA, if you want to hop off, we totally understand. But if you already have our MSPA certification, you can totally attend this and get your recertification credits. You don't have to take the exam. You usually need only 6 credits to recertify, so you'll be getting 10 modules worth, but you'll get to hang out with us. There'll be a happy hour. There'll be kind of a lot of fun there in person. So it's up to you if you'd want to attend just to get your research done and out of the way. You can certainly do that. Otherwise, you can get your certification credits through the platform. We already have, I think, 1 up. We'll have 6 total here coming up very soon. You'll have them all in the platform. And then we were looking to the future to also, work with MSPN and provide, a credit here or there through an organization like that. So great questions. Thank you all so much for your time today. And we'll make sure to answer people's questions offline.
Thank you all for attending. Have a great day.
Thank you, everyone.